Ben, there's a lot of discussion about your ordinance. Thank you very much for writing it.
Sure.
I think we should go maybe to Diane first because she has a lot of knowledge, technical knowledge about CAFOs. So Diane, are you ready to go?
Hey, Ben.
Hello.
Hi. Um, so I wasn't involved in writing this first draft, but I did give some input, and when I read it initially. So now I've read your draft, which I like very much. I really like all the stuff that leads into the prohibitions and a lot of the stuff I don't understand. All the technical stuff later on, but in terms of the prohibitions, I had some thoughts on it, and I wanted to just kind of run this by you. So when I read this, when I sat down with the group that wrote this, we kind of talked about a whole lot more, many points to put in to prohibit in the county, and what you have here is probably less than what we had talked about. So the things that I'm looking at are, for example, you have it's unlawful for any corporation or government to engage in vertical integrated livestock farming, not already in operation. But there are instances where you have confinements that the hogs may be, they don't work with the smaller, and they don't necessarily work with the big integrator, but they may have their own hogs that they are, raising and farrowing and, kind of generating themselves, but they're still within a confined facility, and they're still breeding all the bacteria and creating all the environmental impacts. They're still, putting that manure on the ground, etc. So I think those would be important to include as well, some verbiage along those lines.
Let me. Okay, there's a lot here, and I'm not sure. I don't think we're going to finish it up tonight, but there's a lot to consider. One of them is, and you're not familiar with this type of an ordinance that we put together, perhaps, and I think that's something that we'll need to talk about because it's rights-based rather than regulatory. If you try to regulate CAFO, I just want you to know that under court decisions in Iowa, I'm looking at one. It's Worth County Friends of Agriculture versus Worth County, and that's a case that's cited as saying that county ordinances that regulate activities that were part of livestock confinement operations are expressly preempted. So so we have to be careful how we do it. I'm not saying that it's impossible, but the reason for doing it in the context of protecting rights is so that we actually don't run afoul of the preemption piece. We're actually able to say that the preemption or the prohibition is really about protecting rights, and it's not about trying to regulate an industry or an activity. And that may seem like a fine point, but it's about all you've got in order to escape from this preemption thing.
Okay, so then basically it just makes it a little bit weaker because of the.
Well, let me just say there are a couple of pieces missing from the draft that I sent you.
Yeah.
And it's not a final by any means, and it wasn't intended to be. It was meant to be a starting point. One of the things that we can do with that, when you look at that prohibition, it says so it'll be unlawful to engage in vertically integrated livestock, and it says corporations can't. What's missing, among other things, is a definition of industrial and vertically integrated livestock farming.
Right.
Which, if we put that in, what we can do is, within the definition itself, perhaps capture most of what you're talking about.
Okay.
so that the prohibition is short and sweet, but the terms you use, what you're prohibiting, are then defined in the definitions section. And so what I'd like to do, and maybe this is something you could help out with, so you're knowledgeable about what it is that you're trying to stop. If you could kind of write up what it is, what these things are, that kind of just the laundry list of what needs to be prohibited. That would help me to organize this better. When we go at it this way, too, we're also prohibiting, it's not the individual landowner or farmer who's actually going to be the culprit here. It's the contract that they have with, who they sell. A lot of times it's the vertically integrated structure is where there's a contract between the landowner and the corporation, and the animals don't even belong to the farmer or the landowner,
Right.
who tends them, and has to put up the infrastructure and the confinement pens and all of that based on the contract, not based on what they might do if they were just raising hogs or whatever. They have to do it according to the contract, and they have to give, for instance, whether it's growth hormones or inoculations, antibiotics, and the rest of it, what they're fed, where they buy the feed. A lot of that stuff is often included in the contractual agreement, and it's the contract that we go after in an ordinance like this. If that's not capturing everything that you want, we can talk about that, but I'm just trying to tell you why I use the term vertically integrated livestock farming. We could certainly do something else, but I'm not trying to tiptoe around the preemption because we're already saying we're prohibiting these things to protect rights. We don't see that as violating the preemption. We see it as a protection of rights.
Okay. So then the part that we had in here, the original that we had, where we're talking about the routine administration of antibiotics in animals or their feed, you're saying that could be included within the broad context of that definition?
It could be, but it would be could be one of the activities, which would be then couched within the context of this contractual arrangement.
Okay. Okay, that would make sense because they do get the feed from these big integrators. So
yeah.
Okay.
So when I say vertically integrated, in other words, there's a corporate structure that owns, that controls the antibiotics, controls the hormones, controls the feed, controls, the only thing that's left a lot of times for the landowner, the farmer, is to go to the bank, get a loan, and be responsible for paying for the infrastructure, for the confinement pens and the cesspools and the rest of it.
Mhm.
And so we want to capture it that way.
Okay.
Ben, this is Tom Kristofiak. I had a question about your original point about the court decision in Iowa saying that county ordinances cannot regulate livestock operations.
Well, right. They can't livestock confinement operations. So regulation of that is preempted. What we're saying is we're not regulating them. We're prohibiting things that violate rights, which is why we need the Bill of Rights in there.
Right. So perhaps you could help elucidate that a little bit, because as you said, it's a rather subtle distinction, because the reason you would try to regulate something is because you feel it's violating rights. So how do we make that distinction exactly?
Well, no, that's actually not how the state proposes the regulations. With the state legislature regulating different industrial activities, whether it's factory farming or it could be mining or water withdrawals or all kinds of things. Often what happens is the industry, and in this case the agribusiness industry, goes to the state legislature, gets laws passed, and even oversees and helps draft the regulations that they're going to be subject to, which is why the regulations don't really protect us, because they're happy to have regulations in place that they can live with and they can profit while they're in place, because then they can claim, well, you've got all the protection you're going to get. And so the regulations aren't actually there to protect rights. Essentially, they're there. It's a smokescreen. They're there to shut down community opposition and protest, so that when you go to the regulatory agency, they'll say, well, we're enforcing the regs. But the regs aren't really protective of your rights. They don't go far enough.
Yeah, I can understand that the existing regulation system is skewed that way. But what I'm trying to get at is, it sounds like you're saying it's possible to do something quite dramatic on the basis of rights. That is to say, we're going to prohibit, which is, to me, a much larger action than saying we'd just like to also have some impact on existing ones or whatever. But prohibit any future, you're taking, concrete action to prevent certain activities on the basis of rights. But so maybe I'm getting hung up on the word regulation or regulate. That has maybe a technical meaning that I'm missing. But it sounds like you can obliterate something, but you can't regulate it.
No, that's not quite true. Sure, you can regulate things that don't violate rights. You can regulate a lot of different things. If it fundamentally is going to violate the rights of the community, the rights of the neighboring landowners and the people and the kids and their health and the rest of it, then we have the authority to actually ban them. Now, under current law, the state is saying, even though we know it harms your rights, well, they'll never admit that, but even though it actually harms your rights, they're only going to allow you to regulate it to a certain point, up to which the CAFOs, the factory farm folks, can make the profits that they want to. And if that's harmful to the rest of the community, the preemptive part caps how much protection that you can impose through regulation. Now, what these community bills of rights are doing, and we've worked with lots of communities on them, what they're doing is saying that fundamental rights, your right to clean air and pure water, you have a right to life, and your life is contingent on the right to clean air, pure water, healthy food and soil, and the rest of it. And so you have those rights, and they're higher law than the regulatory laws. They're higher law than the state statutes. The state has no authority to violate those rights. And so we're intentionally putting them in place in the ordinance to say, here, this is the higher law. The prohibition is to protect those rights. And if there were to be a challenge to an ordinance of this sort, rather than simply being able to say the state preempts the county from enacting a law like that prohibits something, because that's regulating too much, they would say. And we're saying, no, we're not regulating that activity per se. We're stopping something that violates rights. And the state can't stop the county from doing that. The county actually has an obligation to protect the health, safety, and welfare of members of the community.
Okay, I don't want to dwell on this too much. I'm just trying to make sure I get seems like a pretty critical understanding and a distinction here. So, are you saying it's not possible? It's not proper words, or it's not proper understanding to say that that it's possible to regulate something because our rights require that it be regulated?
I think that a community can decide to regulate certain things without prohibiting them. But under current law, that's not allowed. They've put a cap on how much you're allowed to protect yourself. In other words, they've preempted or they've usurped the local government's authority to act on behalf of the community and regulate or prohibit certain things that are simply on their face harmful to the community. And so invoking the rights is the way to trump that. So when I use the word regulate, what I'm talking about the term for me means to allow with certain conditions. And so a ban is not a regulation. To allow under certain conditions, that's to regulate. Unfortunately, the conditions that are acceptable to the state are not acceptable to the community, or you wouldn't have gotten in touch with us. Apparently, what's being enforced and what's in place is not protective of the community. And so what are your options? You know, you can do nothing and you can get the CAFOs with all of the things you don't want and try to enforce the existing regulations, and you get what you got now because that's as much as you can invoke rights and say, we're going to be more restrictive. We're going to say no to this.
I have another thing I wanted to ask you about, Ben. Two things. So we had in here that, well, it's a little muddy, but basically we had in here that we wanted to require, and maybe this is what's falling under the regulations, and maybe this is why it's not in here, but we wanted to require that CAFOs that are already in existence that are less than 500 animal units submit a manure management plan, because right now they don't have to do that, and we don't know where they're putting manure and if there's overlay, if several CAFOs are putting it on the same place. We don't know that, and so we had put in here that that we wanted to include that. Would that fall under the I mean,
yeah, you're right. Your instincts are right. That really comes under regulation, and it also becomes something that the state would, and any opponent, the farmer or the corporation, would have a pretty, I think, pretty easy path to overturning that. More strict state does, then you're kind of screwed.
Okay. Yeah. Can you say that again? Because we lost you as you were. We lost some of that.
I think that you're just, because the state preempts any more stringent regulation, and because that's a specific regulation of a aspect of the activity. It's not just the whole activity is harmful. What you're asking for is specific regulation. I think that any challenge to an ordinance with that in it would be successful.
Okay.
And so what we have, there are other things that can be put in here. I want to be real clear. This is the first draft, and I do want to hear your concerns and what you want to accomplish. Some of them maybe we can. Mm-hmm. For instance, we have an exception to farming that's already in operation that the prohibition won't apply to. So it's not going to shut down a CAFO that exists. It's going to stop any new ones. That's not up to me to decide, okay? That's for us to discuss. But if you put in, we're shutting all of them down, you know that there's immediately going to be and given that, the likelihood of the county supervisors actually enacting the ordinance are slim to none.
Yeah, I would agree. I think we were, when we were writing this up, we were kind of aware that would be pretty much impossible, to get rid of once.
Well, let's look at go ahead.
However, one of the things that we had in here too is that if an existing CAFO was sold, that they couldn't do that and allow it to continue to operate as a CAFO, that we would want to just end the production at that point. Can we do that within the structure?
Yeah, I think that's one of the things that we could do that. I think we could say that, when I say vertically integrated farming operation, and I'm focusing on the contract with the corporation, the outside corporation contracting with the landowner, that's what we're actually we're regulating or we're banning, is that contract of any new ones. And if one expires, in other words, one sold or the contract expires, we can say that's the end. It can't be renewed.
Mm-hmm. Yeah, good.
I mean, that's something we could add. Yeah.
Okay, great. And then
We could also do something on the, if you look at section C, talking about the CAFO manure for inside the county to be stored, applied, or used anywhere in the county. We might be able to capture stuff about the existing or the produced manure. You know, I'll just have to think on how to integrate that into the prohibition.
and how again you were dropping out a little bit. So
Sorry.
what aspect? Me?
About the existing CAFOs rather than just CAFOs outside of the county, not bringing it in. Mm-hmm. I'm trying to think how we could try to include what you're concerned about with. They don't have a lot of states have what they lovingly call nutrient management acts,
yes. Mm-hmm.
and so they call them nutrients. And one thing in Pennsylvania, for instance, the one of the few regulations on these CAFOs is that they have to submit a nutrient management plan.
Right.
You're saying they don't in Iowa?
No, they do. It's a manure management plan, but anything that's under 500 animal units, they don't have to do that, and they should.
I see.
If they're gonna do this, you know, to me, they should, because they're generating manure too.
Well, the ordinance was drafted with the large operations in mind. I'll be honest, and I don't know. I'm not sure about capturing that, because I think that we can try and make the ordinance do more, you know, a lot of more things. But the more complex it gets, the less likely it is to be enacted.
Right.
And the more resistance you're likely to have from your smaller operators.
So it's balanced. You just have to look at this as a balance.
It's well, and I'm not trying to tell you what you need to do. I'm just, you know, trying to give you the, you know, from our experience with this stuff, you know, what you run into.
Mhm. And then the last thing I wanted to mention was we had in here, we wanted to nullify the air gag law that we have in Iowa. Can we do that?
and they say I'm crazy. I don't know what's in that law.
I think the way it's written is that it's illegal to pass yourself off as an employee of a CAFO in order to basically go undercover and take photographs of what's going on with the animal abuse and all of that.
Oh, okay. So in other words, yeah, I got it. So it's Pennsylvania passed something similar, and others have too.
Right.
What they've made actually here, they've made it illegal to take photographs of farms.
Wow. Wow.
That's pretty bad, huh?
Oh,
so I don't know that makes sense to include that.
Yeah.
The state itself and the county and the attorney for the county would at some point begin to say, look, an ordinance has to be about a single subject, not about thousands of subjects.
Yeah. Okay.
And so that would be a separate ordinance, I think.
Okay.
I wanted to talk, and I'm sorry to interrupt a little bit here, but just to say for completeness, when it says it's unlawful for a corporation or government, there's a reason for the government to be put in there, because we also, under Section 3C, nullify any permits that are issued to do things that are prohibited by the ordinance, so governments are included. In other words, governments aren't allowed to violate rights either, which we already knew that. I mean, anybody involved in the law knows that. But another section that I think needs to go in, and we've included them in other ordinances dealing with factory farms, would come after Section 3. It would be exceptions.
Hmm.
And I'm not sure there's a reason that there's a definition of family farm corporation. And that is that rather than trying to target operations that are owned and operated locally, and owned and controlled locally, where like 75% of the operation minimum is controlled by an actual resident family. That we're not out to shut them down, but what we're trying to do is shut down the control of agriculture by the agribusiness folks who are actually bringing all these nasty practices in.
Right, that makes sense.
Does that make sense? So in other words, there would be an exception for family farm corporations, because families sometimes incorporate their farms. They just do it. It makes sense legally for them to protect their assets and have limited liability and all of that. So they do it. And if you don't put the exception in, and I'm offering it as an option, but most of the communities we've worked with thought it made sense to exclude from the prohibitions local farms, locally owned and controlled farms.
I think that's
Now,
in here.
now a lot of farms, though, here, at least in Jefferson County, a lot of them are like these LLCs that are family owned, but they're like contract growers for the integrators. So,
Well, right. And so they're not actually family farms if they're contract growers.
okay, so then the definition would have to be, I guess, include that the family farm is not working with the integrator.
Right. So when I put in the definition of the vertically integrated livestock farming, then that would be defined as the contractors. Okay.
Okay.
So that's so any new contracts, any new contractors of that sort would be not allowed after adoption of this thing. In other words, the whole essence of the ordinance, in general, as it stands, and with some of the changes that I've been talking about, what it would do is say no new CAFOs that are through the contract system. And the reason is to protect your community's rights to clean water and a healthy environment and clean air and the rest of it. And it's based on another fundamental right that's mentioned first off, and that's the right to local community self-government, that the people affected by governing decisions get to make them.
Mm-hmm. Okay, good.
And that's the essence of the ordinance.
Okay.
I know it looks a lot different from what you folks put together, and I know you put a hell of a lot of work into it. The thing is, I think what you've got is kind of a cross between an ordinance and a part of a home rule charter. But in Iowa law, and I think it was in the 70s, the state enacted a new constitutional amendment recognizing county home rule, but they never, from what I can see, they haven't allowed them to draft their own home rule charters, which is like a county constitution. If they had, you could pack a lot of stuff into it, but the state hasn't gone that far. They pretend it's home rule, but it's really something else.
So then we can't work. I mean, if we can't get our county supervisors to adopt this, then are you saying we don't have that home rule option to?
We don't have the power anymore.
Sorry?
So basically,
You mean,
if we can't get our supervisors to adopt this, are you saying that we don't have any power to implement a home rule charter?
not that I can see, but I'm going to do some more research for you. I don't believe there's any initiative power. In other words, to circulate petitions and put it on the ballot.
What about Iowa City?
Really?
They're
Oh.
a home rule city.
Oh, that's true. Iowa City is a home rule city, so they must have done
Well,
something.
cities, yeah, there is home rule cities that have charters, but what I've found so far is that counties are usually seen as subdivisions of the state, and the state jealously guards that control, and in many states doesn't allow them to have their own charters.
Hmm.
Yeah,
and in other words, doesn't allow the citizens to propose ordinances, or what would be even more powerful is amendments to the charter.
Ben, when we were organizing a few months ago, somebody pointed out a sign. It might have been Greg that actually refers to Jefferson County Home Rule. And
Right.
so we tried to research what that meant, and I contacted the law librarian in Des Moines, and nobody seemed to really know. But later on, I found out that Iowa may have repealed Dillon's rule, or is no longer observing Dillon's rule, and that's related to what you're talking about, that the home rule provision for the counties is only to do with Dillon's rule. It doesn't do with state preemption.
No, yeah, and I'm very familiar with Dillon's rule, and there are various forms of or degrees of home rule. County home rule came into existence in Iowa in November of 1978. But what it does, and they call it home rule, and it's an amendment to the Constitution for the state. But what it doesn't actually allow them to have their own charters. And I'm going to dig into it because from what I can see, I don't see an initiative and referendum authority for the citizens either. They can enact laws to protect health, safety, and welfare, and we'll point that out to the commissioners if that's who has to pass this thing. They have certain powers and all of that. They can't pass laws that are inconsistent with state law. The point being, in terms of making this a rights-based law, is that no state law can be inconsistent with protecting rights. I mean, that's an absurdity in itself. And so it's if all we've got is the county supervisors able to enact a law, and if that's the only tool, I can tell you that we've done it in other communities. It takes some education for the community. And part of our discussion about this ordinance and the language in it, part of the reason that I regularly work with communities, their local groups, and say let's go through this and work on it and amend it and change it, come up with new ideas, new ways to put it together. But there are certain things that have to stay in there in order for this thing to float and make it work within the given law's context. And through that process, I hope you folks get to understand this thing very well so that you'll be able to convey that to the county supervisors. They're going to need the education before they're going to be willing to do anything.
This is Bruce Grady. So to follow up on your distinction then, Fairfield could become a home rule city and then proceed to initiate laws or ordinances that would specifically within Fairfield city limits disallow things such as the smartphone type, smart meter types of things. But we obviously being not any agricultural things inside Fairfield, we couldn't do anything with CAFOs, but Fairfield could do initiatives like you're talking about if it was a home rule city, right?
That's correct.
I see.
Yeah, and a home rule, what I would do if it's a home rule community, if it has a charter, I would be advising not to do an ordinance, but to actually amend the charter to include a community bill of rights in the charter and then the prohibitions in the charter. It actually is stronger than a freestanding ordinance.
Yeah, Ben, one of our tactics that we could follow up on is to work with the cities in Iowa that are already home rule cities, such as Iowa City, and try to find a pain issue that would allow the grassroots to grow to where we could, because the research that we did, which is not complete by any means, but we couldn't determine whether any of the home rule cities actually have a Bill of Rights. And I doubt they do.
My guess is that none of them do. And the only cities that seem to have bills of rights, and well, let me put a caveat on it. Over the years, some have begun to put in things like voters' bills of rights or renters' bills of rights and so forth. But by and large, most cities and most counties that have charters in the country have no bills of rights in them, except for the ones that we've worked with. And I think there's a real value in having it. It's not just simple poetry, because depending on how you run things.
Yes, Ben, this is Richard Walbaum. I'd like to change the topic. In Section 2, Point D, Rights of Natural Communities and Ecosystems, you say, natural communities and ecosystems possess rights to exist and flourish within Jefferson County. And I have some issues about giving nature rights. For example,
I did, if I could, I did read your piece, and I just wanted to clarify before you go too far with it. The rights of natural communities and ecosystems, this is not an animal rights provision. In other words, it doesn't protect rights for any individual deer or cow or dog or frog or turtle. It's about actual ecosystems and natural communities. And it actually, the reason for this, what's unique about it, is that it's been maybe counterintuitively, but it was first enacted in very conservative, I would say, communities, because they found it to be a powerful tool for the community itself to protect its natural environment. Because under current law in the United States, and I understand that you're keen on property rights, but that's a problem for folks that want to be stewards of their local environment. Because under current law, a landowner, or say I own land and the river runs through it, I can pretty well do whatever I want to kill the river and the forest and everything in it, because I have property rights over it. You know, it's so nature has, under current law, the status of a slave. As you know, slaves were property, and the slave owner could do anything with a slave, because property has no rights. What this does, it's the simplest way to put it in legal terms is, it gives standing to the members of the community in court to protect their ecosystem, even if they don't own the river personally. Because under current law, you have no legal standing unless you have a property interest in, say, the forest or the river or whatever it might be. So again, it's not an animal rights provision. It doesn't stop anyone from hunting. It doesn't stop anyone from fishing or cutting down a tree or whatever. What it does is it protects complex systems from being completely destroyed where they can't regenerate.
I think that the text needs to be clarified to bring out the point that you just raised, that you're not protecting against individual animals being killed and that kind of thing. Otherwise, if it's not clarified, it will just open up a whole can of worms. People will be suing everyone for everything.
Yeah, well, we have a definition of ecosystem and natural community, and yeah, they can be probably improved some and expanded or made more clear. But that's the intent and purpose. We understand, and we've had people say, "Oh, if you include that, that means that I can't spray the roses with insecticide or whatever." And it, number one, it doesn't at all do that. But number two, just in practical terms, if anybody can sue anybody for anything, even without an ordinance of this sort. The question is, if you do sue over it, does it go anywhere? Does the court hear it? Or if the court hears it, do you prevail? And how many people want to go to court and spend a lot of money on a frivolous case and hire the lawyers and the rest because somebody, ran over a frog on the road or something? I mean, it gets to the point of being ridiculous. And so, we try to make it clear. We need to be cautious too, that the more you define, the more specific you get, the less inclusive you can be in protecting things.
Yeah, there's been some history having to do with the kangaroo rat, the San Joaquin kit fox, and blunt-nosed leopard lizards. They were protected species under the Federal Endangered Species Act. And in 1994, when a farmer in California tried to plow his land, the federal government filed suit claiming they were kangaroo rats on his land and they were protected. And many farmers in the area were angry. And so I'm just afraid.
Yeah, the thing is about the Endangered Species Act is it's not a rights-based act. It's an interstate regulatory law, which is why the federal government can get into it. And they made some really silly arguments in court that, well, because animals don't respect municipal or state boundaries, then they can be lumped under interstate commerce, which is, when you think about it, kind of crazy. But that's what they did. And again, this doesn't have anything to do with any individual animal or whatever. It's, and it really is more about what the community, what the county, what you folks want to do to protect your environment, and if it matters to you or not.
Okay.
Ben, we're starting to get into an area that I think is very, very rich, or maybe too rich. But one thought that occurred to me is that I don't really think it's logical when you explore it to give anything other than human beings rights. For instance, in the example that you brought up of the river running through private property, and the point about standing, which I think is very important for us to know, it seems to me that standing would belong more directly to the people downstream, not to nature, but to the people who are impacted by what the property owner might be doing to the water running through his land, because the water doesn't stop at the edge of his property. So,
yeah, but everything you're describing here is keeping it within the confines of property rights. One of the problems we have under current law is that property rights are seen in many courts and under many laws, property protection of rights in property as higher rights than human and civil rights. And that means that the community, unless they have a property interest, have no authority to protect their own environment, their own ecosystem. The focus of a community bill of rights, a community rights ordinance or amendment, is to empower the community, to make the people living in the community, to protect their rights and to make them essentially captains of their own fate, whether or not they own the place, the environment. Downstream might be out in another county. So those folks, if they're unhappy because somebody upstream in Jefferson County did something that poisoned the water and killed off the fish and the rest of it, if they go to court to argue that shouldn't have happened, again, it's a standing question. Well, what is your material harm? In other words, how many dollars did you lose? Well, they might say, I lost my enjoyment of fishing for trout. And the court might actually hear it and say, well, how much do you think that's worth to you in a year's time? And I don't know how much it would be worth, but if it's a few $100s or whatever, where does the damage go to? Well, it goes to the human being whose interest in the fish that are no longer around is now damaged, and they put that $100 or whatever it is in their checking account, and nothing is done to protect the environment. Nothing is done to restore the trout that used to exist there. And you can, I guess the argument has been made and continues to be made that whoever owns the land that the river goes through and is responsible for having done that damage, well, they have a right to do it. They own it, and nature doesn't have any rights. I hear the statement you're making about why should anything but a human being have rights. Well, certainly corporations have rights under current law, and they're just property. And every individual, every investor, every CEO and director of a corporation already has individual constitutional and legal rights. But it's the corporation itself as a legal concept, as the writing on paper, that is seen to have rights in our judicial system these days. I'm not saying that's a good thing, but I think what we need to do, and I'm happy to send you over a little piece about what are rights. It's not about. There are lots of ways to look at it. I shouldn't say it's not about, but some people say that it's some kind of intrinsic value in the person. It's almost like a metaphysical value, like a soul. But we're talking about legal systems and legal structures here, and about how societies decide what to protect with law. This isn't about what has some kind of metaphysical aspect to it. This is about what we can, as human beings, decide to protect through law.
So, Ben, it's very helpful to hear all these points, but I want to just say one thing and then pass this on. It seems like you're wandering away in the points that you're making from the earlier main point that you made, that we can't regulate because we need to refer to the higher law, and this higher law, the right to fresh water. So if one property owner is denying the right to the downstream human being to the right to clean water, that I think we want to continue to appeal to that highest level.
I understand that, and the only problem is that that's where we are. Anyone who feels harmed, you've harmed my water, my drinking water is spoiled, I don't have access to clean drinking water now. They do have legal recourse. They can try to sue. We're dealing with that in the fracking areas, communities that are doing the fracking everywhere, and the groundwater are being destroyed. The problem is that there is no, once you've destroyed an aquifer, there's no way to fix it. There is no compensation. You can hand over dollars to human beings who then can spend it or hand it off to their children if they die, assuming it's a lot. None of that will ever fix what got broken. When we talk about regulation, and I say that it allows things under certain conditions, and under current law, the degree of harm that's done, the degree of harm that's legally allowed under the regulations is in excess of what's healthy for people or ecosystems or future generations. If that's the case, are we going to settle for regulating, or are we going to actually say we can't do it that way anymore? We have to impose the higher law that says you're just not allowed to do that harm to begin with. We're not going to at the end of the pipe, after we've been harmed, sue for the harm. We're simply not going to allow the harm to occur. And that's the essence of protecting the rights, is taking them, putting them up front and saying, you can't go past this blockade here. You cannot inflict the harm and then just pay us for it.
Ben?
Yeah.
Can you hear me?
Go ahead.
Okay, hi, this is Fred Rosenberg, and thank you again for working with us. This is wonderful. I got a couple of questions. Let's start with the first one. First, a term where we've talked about the rights of nature. Now, how about the word commons? Is that the same And
No.
do commons have any legal standing right now?
It's there's so much here. We could take 3 hours to cover the topic. And I'll try not to, but it's pretty complex. The commons, it's still a property term, but it's a collective property term rather than an individual one. And so there was a time, for instance, in England, if we go back before, the Norman conquest or whatever, where there weren't property lines. There wasn't, people didn't have deeds to big tracts of land. They may have claimed an area was my farm field or whatever, but that was through, tradition and generations of family living there and planting and harvesting and all of that. But there were also commons where people would say maybe they would all graze their sheep in common. Nobody owned the meadows, but everybody had access to it if you belonged in that community. Somebody from across the mountain couldn't come over and bring all their sheep, but the people that lived in the area, it was a commons. Nobody had a deed to it, a legal title to it. What happened historically was what they called the enclosures at the time, and that was when the king would simply draw a line around a piece of land and hand it over to a baron and say, it's your property now, here's your legal title to it. And that means you have exclusive use of it, and you can kick those peasants off, and how dare they graze their sheep there anymore unless they pay you or they give you some of their crops. They didn't call it taxes then, but tithing or whatever. And so the privilege of that one baron and his heirs to claim ownership of that piece of the planet, that part of the planet, that came from what? Well, it came from privatization of what had been the commons. And we've got law, English law, and then American law coming, built on that, that protects more the privilege of the baron than the rights of the people to live and have food and have clean air and clean water. That was just a common right at some point, and for much longer history than there was ever the claim to that enclosure. So the commons is about property ownership as a communal thing rather than as an individual thing. Nature recognizing rights. It's a legal trope. It's not claiming that trees have souls or rivers have some character other than the fact that we're recognizing a community value in imposing a legal protection on it that can't be violated. Even if you own the river, you're not allowed to kill it.
So, is the word common something that we should avoid?
Well, I'm not trying to tell you what words to avoid, but it's not an accurate description of what this is about.
Okay. All right. And then the other thing is you've been using an idea which seems pretty powerful, that some laws are higher than others. Is this kind of a common sense thing, or is there some legal standing to that concept?
I like that you use the term common sense. It goes right back to Tom Paine, who wrote that paper called Common Sense that inspired the Declaration of Independence. And in the Declaration, what we hear, at least the American government that was established, throwing off at least the real radical folks who were fighting the revolution. I'm not talking about the elite folks who wanted it to be, just a new empire, but the folks who thought they were fighting for liberty and the rest of it, believed that we have the right and the authority to create government in order to protect and secure rights of the community, of each member of the community. And that includes the right to property. I'm not knocking down property and saying it can't exist. I'm saying, it's more, but property is a little different thing. If you go back just, 100 years, it wasn't your right to own dividends and interest. It was your right to own the fruit of your own labor, what you earned from your own sweat, from your own effort, not what you got from a contract that work better for you than the other guy. And it's more complex stuff. And I'm not sure I answered your question, but
kind of. Let's see. I think I made another note here, or from in the beginning when you first started mentioning this. Our rights are higher laws than regulatory laws.
Well, and the claim comes from, and it's a cultural decision. It's I'm not trying to make it a metaphysical thing. It's a cultural decision. What's going to work best? If we're going to live in community, and we sort of have to, because we like it or not, we want to be rugged individualists, but in a nation with 350 million people and a world with, 7 billion, we're going to have to deal with each other. And that's technically, in the best sense, I think, why we create any kind of government at all. It's to make sure that my right to swing my arm ends where your nose begins. That you have the right not to have my knuckles on your nose, and just figuratively. And so rights aren't, when I say unalienable rights, they're rights that they belong to everybody equally, just because you're born, just because you exist, and that government, law, regulation, the state statutes, constitutions, they can't violate those things, because that would break down the essence of what we're agreeing to when we say we're going to live together as a society. When you don't do that, when you say we're not going to recognize those fundamental rights as the highest law, what that means is that we can go back to a time when special privileges were higher law, when the nobles could have their way and the majority couldn't. And so in the Declaration of Independence, I use that as the model. It talks about that people are born with unalienable rights, and the governments are instituted to secure those rights. And when governments don't do that anymore, they're no longer serving the purpose for which they were established, and the people who are having their rights violated have the authority to amend, alter, or abolish them. I mean, that was the assertion. Not everybody's going to agree with that, especially people who have special privileges who want to hold on to them are going to say, no. We're not going with that. We're not going with that plan anymore because it doesn't work for me.
Right. So is the statement that the rights that we want to establish here are higher laws than the regulatory laws? Is that an argument you would make in court, or is it a legal thing, or is it just, again, a common sense thing? Are you still?
I am starting another recording.
Okay, Ben, I had a question for you. This is Richard Walbaum again. I'm wondering if you read all of my article, the second part of it.
Sorry, I'm having a little trouble hearing you.
Where's the mic on the top?
Just put it closer.
Oh, okay. So I'm wondering if you read my suggested alternative to giving rights to ecosystems. It was the second half of my article having to do with nature's rights.
You want to couch it in property rights, which is, it takes us back to, it's kind of a circular trail that brings us back to where we are.
Yeah, well, I wanted to promote community wealth, commonwealth, which you were just talking about commons. And I'm thinking if we just promote community wealth, we can get everything that we want without any distortions in the law.
More than you think by doing that. And it's interesting that back in the 60s, Supreme Court Justice Douglas was brought and
You're breaking up.
Come and sit over here.
Can you hear me?
Yeah, I can hear you now.
It's because a river can't show up in court and make a rights appeal to the court, obviously. The model, the legal model for this is, for instance, a child that has no legal agency of its own. It has rights. The child has rights, but can't show up in court and speak for itself. And so what usually happens is there's an agent or someone who is appointed to intervene and stand speak for the rights of the minor. In a similar way, these ordinances, they obviously don't say that the river or the forest can go to court. What it says is that any member of the community can go to court to advocate for those rights to protect the ecosystem. It accomplishes what you're talking about, I think, without going so far as to say, oh, by the way, that forest that's on your property and that river that's on your property, the community actually owns it. I don't think that you're saved from confronting the property system anymore by doing it that way.
Okay, I need to consider that, take a look at it more carefully. Thank you.
I don't know if we were thinking to talk about strategy today, or if we're out of time, or what.
Well, one practical, simple question would be... I
was going to mention something, too.
Would there be any wording changes when we adopt the final ordinance from a county to a community? Or can we pretty much just substitute Jefferson County for the name of a town, for instance?
I wouldn't do it quite that easily. I know that it'd be nice to, but rather than use it as a boilerplate ordinance, I think that whatever the given community is, let's say you wanted to do something in a city that has home rule, or you wanted to do it in a town that may not, I think that, the usual way I go about it is I work directly with a core group that lives within that municipality and work with them on it so that they become very familiar with the ordinance. And we customize it for every individual community for two reasons. One, because if we really believe in the right to local self-government, it shouldn't be something we just slap in front of them and say, here, go pass it. That it should be something that they have ownership of and have buy-in. The other piece is that through working on the ordinance language itself, those in the community who are going to be proponents of it will become very familiar with it. They'll be able to make the case. And just as you're giving me questions, I'm fielding those questions and trying to explain the rationale for doing it this way. Those people in each community need to be able to have that experience and get educated about what the ordinance is and why it's done this way. So when they're asked questions, and I'm not there to back them up or to answer, they're more able to do that. They can articulate the rationale for it. They can make the case. And there's a lot more, quite frankly, in terms of how to make the case. And this goes to strategy. How do you persuade elected officials to enact something that on first blush they're going to say, well, we can't do that. We're preempted from saying no to the KFOs. And the attorney for the municipality or for the county will advise them, oh, no, don't do that because we're preempted. How do we make the case to them that this is different? This isn't regulating in a way that the state says you can. That this is really about the authority and actually the duty of the elected officials to live up to their oath of office to protect the health, safety, and welfare of the community, to protect the rights of the members of the community, and that the state has the authority, that it can't legally or legitimately stop or preempt them from protecting the rights of the community. And, I'm just shortening up the argument here to give you a feel for where you have to go. It's about really making the case that this is their job. And if they're not going to protect health, safety, and welfare and rights of the community, you don't need them. What do we need local government for if it's not going to use the authority of the municipality to make law, And if they're not going to use the resources of the community to protect those rights, what do you need that government for?
That's
I guess maybe to plow snow in the winter, sure. But we need it for other things. And it's not for these really basic, important ideas of protecting rights. Then, the whole point of government is lost, at least as I see it. And going back to really original traditions of the Declaration, which was intended to be different. It was intended to establish the idea that the people living in the community are the source of governing authority, and consent of the governed is required for law to be legitimate. And if law that does not have consent of the governed is established, then those laws are illegitimate. And we've got to be able to make those cases and argue the case firmly and convincingly. And that's what I hope. If you folks are interested in this after our conversation, if this makes sense to you, our job isn't just to write an ordinance for you, but to help bring you up to speed on how to champion your rights and how to make that case.
This is, people are applauding. This is, we're going to be starting a new conversation is what it amounts to. And you really, we have it recorded, and you were extremely articulate and inspiring, I thought. I wanted to mention in this, talking about elected officials, that just so that you know this too, that we're going to have a lot of electoral change coming up soon, because someone told me today that the mayor was going to announce that he's, in the next week or two, that he's going to run for state senate, and after how many years, 15 or 20, not be in the mayor's office, and then there'll be other city council seats. So there's going to be a lot of change, and I think, in the ideal world, we would use this to our advantage. And but
there are ways to do that, and one is to make it, after you're familiar enough with these concepts, to make as a litmus test for candidates for office, to get out, make the case, articulate this stuff, and ask, do you support this? Do you support a community bill of rights and the authority of local governments to be used by their community to enact and enforce protections of rights? Do you support that? I mean, and without going too far with how you go about it, that's certainly a tool you could use to distinguish between preferred and not preferred candidates.
yeah, that's great. And here's Bruce. He wanted to ask you something too.
Sure.
At the bottom. Hold it at the bottom.
Now this may make you and everybody here angry, but I'm denser than most perhaps, or have friends who are more vituperative than most. And so you made a beautiful statement earlier about kind of disarming the implication that individual mosquitoes could be protected and sued for or against. And on the other hand, or as an extension of that, we still have people who, when we go public, will be bringing up the whole freaking out about some statements of about Agenda 21, etc. I need just some short, perhaps, ammunition on how to disarm that fear that what we're really driving for, and especially the whole Thomas Lindsay group is really driving for, is people being kept off the land and made to live in super high-rise buildings, and you can't even go into nature because nature is so sacrosanct that it's completely protected by the world government. How do you answer that?
I answer it by going back to my original statement. I and our group are not at all in favor of centralized government and control. What we're interested in advancing is the people directly affected by governing decisions to make them. That's my definition of democracy.
That is perfect.
And by the way, I mean, I've heard this, and in some ways it's frustrating because we're working on our stuff, and people that love to pin us to some other idea, whether it's Agenda 21, which, by the way, I've never read. I've heard about it because people began to accuse us of being tied into it, I don't know, a year or two ago. All I can think is that there's some agenda there that, besides Agenda 21, that wants to short-circuit what we're doing because we're not making some powerful, wealthy people happy. And they're happy to have us fight each other rather than fight them.
Man.
Agenda 21, and I think it has to do with the UN, right?
Yeah.
Yeah, well, the UN, in my opinion, and we talk about it in our staff, is like the worst and last place we go to appeal for any kind of help or assistance. Number one, it's an ineffectual organization, and I guess the folks who believe that somehow there's a nefarious plot, and who knows, maybe there is. They don't invite me to their little cabal meetings if they have them, but I don't believe that the UN has ever been effective in enforcing anything, including in the universal rights of man and things like that. It might be worth. It'd be maybe a good thing if the UN would be able to, but it doesn't. And it's got a Security Council with nations that are on it, and it's not democratic. It's only powerful, wealthy nations that are allowed to be on the Security Council. And as it turns out, some of those folks are like at complete odds with each other and can never get anything done. I just scratch my head sometimes and wonder, why would anybody worry about something, some study or whatever that was, put together by the UN? What I'm being more concerned about is what's done by, the big wealthy corporations getting together to do NAFTA and TPP and things like that, because they don't invite communities in to ask what outcomes they want. They just come up with new rules for everybody, and rules that allow companies to sue states and municipalities if they interfere with their money-making process. That's the kind of stuff I worry about, but frankly, I don't spend any hours of the day wringing my hands about that either. We've got a lot of work to do, and I think let's not lose sight of what we're trying to do, and that's to empower communities to create the outcomes they want. That's certainly the opposite of centralizing power and control. And so I think it's kind of funny that anyone would identify us with the opposite.
Thank you. You are the Abraham Lincoln of natural rights. Or I sure hope that this recording comes out well, because that is a necessary statement.
Hold it at the bottom. Not there.
Some of the stuff is just so silly that I know people get really wrapped up in conspiracy theories, and I know that's all very entertaining, but it sure distracts us from getting anything real done.
Ben, getting back to the mundane, could you clarify for us something that we've had quite a bit of discussion here in two of our communities, which is the land in the county surrounding the city that is subject to annexation. Does the city actually, can the city write an ordinance for that land? Or
I'm going to have to plead a little bit of ignorance here, but my familiarity with annexation in the various states, it varies to one state to another what the way it's done, but it's not simply writing an ordinance. That's not how it happens. I'd have to check with Iowa. Look, I'm not an Iowa attorney. I can't give you a lot of legal advice about Iowa law, but we can all look it up. But I would bet that there's a process that there's got to be a petition of people who live in that area, and there's got to be a petition from the city, and it probably has to be mediated by the state legislature. It It's not something where the city can simply say, I'm taking over. That doesn't mean it couldn't happen. And so just to be clear, large cities often enough annex, surrounding suburbs and towns, and often enough in our history, it's been the business center that does it, and the reason they do it is they'd like to have a bigger tax base, and then that tax base goes to fund what the wealthy center city business group wants, which explains why we have a lot of. Look, I grew up in Philadelphia, and it was 1858 that 28 separate municipalities had their local governments dissolved, and they were all annexed by what's just Center City, where all the big buildings are. And what's Philadelphia now is made up of what used to be 28 other municipalities, towns and boroughs and so forth. They didn't have any option because the state legislature agreed with the merchant class folks in the city and allowed it to happen and just dissolve those municipalities. We haven't seen that kind of wholesale annexation for a century or so, in a lot of places. But does it happen? Sure. And the people living in those 28 different municipalities at that time were told, sit down, shut up, you have no right to say anything. We're just taking away your local governments. Our approach to things is the opposite of that. We don't think there should be an imperial city either. And when we talk about doing community rights organizing in big metropolises like that, frankly, we've looked at putting together we haven't been able to do it. It's a bigger job than we're up to right now. But imagine a city like that having each one of those 28 what had been individual communities reinstated with their local authority to decide things about taxing and about development and the rest of it. What if we actually returned authority to when I say community, I don't mean the city. I mean neighborhoods. I mean where people live and they identify themselves as a community. So, it really is about local control.
Yeah, that's a fascinating response. But to bring it back to the Fairfield area, and we were wondering whether, due to the difficulties we talked about earlier of passing an ordinance in the county, that there might be a strategy whereby the city of Fairfield could pass an ordinance that would lay claim to rights to block CAFOs in this buffer zone, that land that would be subject to annexation. Is that a valid concept, do you think?
I don't know. I think, we've had cities or we've had non-rural communities like boroughs, smaller towns, have enacted ordinances like, ban on factory farms, where they were not likely, they might have had some farm area, but not likely to see much of it. And they've enacted them in order to set an example for the more rural surroundings and for the county. That might be a viable strategy, something to bother with. In terms of I think the scenario you're talking about seems like a pretty convoluted process to do the annexation and then to do the local ordinance.
No, this would be, Ben.
Is Fairfield home rule, can you tell me?
Fairfield is not home rule, but we're still not connecting. The concept would be not post-annexation, but just because the city has a theoretical right to annex certain property nearby, that somehow that could possibly be translated into that the city could pass an ordinance in that nearby land, and thereby, so to speak, do an end run around the county supervisors.
Yeah, for that area around the city, you mean?
Right.
I think there'd have to I don't know that there is in Iowa, that gives them extra jurisdictional authority over that land. Just because theoretically they can annex it doesn't mean that they can enact ordinances that have power over those pieces of land until they would do the annexing. My guess is that they don't. There are, like in Colorado, the municipalities do have some authority within a 20-mile radius for some activities to pass laws like on fossil fuel extraction, for instance. And that's, to protect water sources and things like that. I don't think that Iowa has such a thing.
Discussion with one of the city council members recently, and we had talked about the whole CAFO situation and what the city could possibly do. And he said on his part that there was a lot of confusion and uncertainty with what the city could do with regarding the 2-mile buffer zone around the city. So I think it's a very muddy issue.
Yeah.
What about eminent domain? How does that, I'm trying to understand, is that separate from like this annexation, and how would that apply in this whole, situation?
Well, again, state to state, the rules vary, and I'm not familiar with Iowa's eminent domain rules, but to characterize in general, eminent domain means taking land, maybe in where the landowner may not want it to happen. They get compensated based on the going value of the land, perhaps. But there usually has to be a municipal need for the land if it's going to be done by a municipality. Now, they could say we're going to take land that is within the city through eminent domain because we want to make a park, or we want to make a, who knows, maybe it's for a road or it's for the new county seat or whatever. There would have to be some actual public use that was planned for the land before there could be an action through eminent domain. It can't just be taken and then sat on as, it's just land we own.
Right, or made into an anti-CAFO zone. Yeah.
Well, I don't know. I mean, that doesn't mean it couldn't be done, and I'm not suggesting it can't. I'm saying it may not be the place to put all your energy.
Yeah. I think we're starting to some people here. So tell what.
I suggest that we revisit, if we can, just to wrap things up. I think that we need to revisit the ordinance. I would ask that folks that have ideas about what should be in, the definition of what it is we're prohibiting, to get those ideas over to me, and I'll incorporate them into the language as best I can, and let you know where it didn't make, some kind of legal sense, and move this thing a little bit closer to a final draft for the county. And we should then schedule, after I've got that done, I think we should schedule another conversation after I've sent it out to you, the updated thing. And, we'll make other changes if we need to, additions or subtractions. And also in terms of the municipalities, the Fairfield or whatever it might be, if folks have thoughts on what they would like to produce there, and it does not have to be about agriculture, if it's a city issue, we can certainly talk about that as well. But keeping in mind that there's just so many people involved and so much time and energy. So how much do you want to bite off, I guess, is the question.
Right, and I think we need to discuss, what's probably the most practical. I think we have had that discussion. I think the CAFO ordinance is really probably the most practical way to go right now. but pretty soon we're going to have to be dealing with the whole smart meter issue here in Fairfield, so, you know, we're going to need to jump on that at some point too.
Okay.
So then after we get together again, the next time we get together, we'll go over the ordinance again, and then if there's time, maybe start talking about some strategies for presenting this to the community. You're going to help us with that as well, right?
That's next.
Yeah.
But so be sure for anyone who has thoughts, you know, send, and maybe you can kind of compile them and send over, rather than me getting from everybody, just send over, you know, a document with things to look at, suggestions for language for defining what's to be prohibited, things like that.
Okay.
Okay?
Okay, great. Ben, this was really great. Thank you so much. You're just so
You
clear and inspiring.
All right, well, thanks a lot, and I'm looking forward to working with you some more.
Same here.
Thank you, thank you.
Thank you.
Thank you, Ben.
Thanks all. Goodbye.
Bye, Ben.